Okay, good morning, everybody. This is the Committee on Water and Land. My name is Mark Hashem. I'm the chair. To my left is V. Maury Power, the vice chair. Today is February 10th, 2026. It's 9 a.m. We're in conference room 411 at the state capitol. Before we start, there's some ground rules that I need to inform everybody. In order for us to have everybody testify, please stand on your testimony if can. We have, like I said, by contrary belief, we do know how to read. And I have read all of your testimony. Anyways, we do know how to read, so we did read your testimony. And if you can, just sum it up or testify in your own words. Please don't stand up and read your testimony. We do need to get to an 11:15 hearing this morning. There's another joint hearing that we have, so if we don't make that, all the bills on this agenda are dead. And we do need to make the floor session, so we do have a time constraint. Please be aware of that when asking questions, members. Thank you very much. Next, so for those on Zoom, please keep yourself muted and your video off while waiting. When you are called up, you can please turn on your camera and unmute yourself. The Zoom chat function will allow you to chat with the staff only. As you can see, I don't have a computer in front of me, so I'm not gonna be able to see your chat function or anybody else. If you're disconnected unexpectedly, you may attempt to rejoin the meeting. If disconnected while presenting testimony, you may be allowed to continue if time permits. Please note, the House is not responsible for any bad internet connections on the testifier's end. In the event of a network failure, it may be necessary to reschedule the hearing, and we will post another hearing notice at that time. Please avoid using any trademark materials trademark or copyright materials in your Zoom background or on your Starbucks. Oh yes, thank you. Our Starbucks cup, because I'm not a Starbucks drinker, so. Please refrain from using profanity or uncivil behavior. If so, we'll have sergeants beat you up and drag you out. Okay, first up, we have HB 1881 relating to land use. First, we have Waimalalo Neighborhood Board in support. Wait, hold on. Do we have anybody here wanting to testify in public for this? No? Anybody on Zoom?
One person.
One person on Zoom. Gil Revere. Representative Emeritus, Gil Revere. And Senator.
Good morning. Good morning, Chair and Committee. Thank you for having this hearing today and hearing this bill. I'm Gil Riviere, Waialua. I'm testifying on behalf of myself and also Keep the North Shore Country. And I just want to share, we'll stand on our testimony, but I want to add one quick thing. Back when we were fighting the Turtle Bay development, the massive expansion some years ago, one of the developers for the resort came and he said, you know, we're so excited about this property. You know, there's nothing here. There's so much potential. We just really see a lot of stuff that we can do on this land. And all of us in the room just rejected that phrasing of the situation. And it was, we said, you know, that nothing to you is everything. That's what makes the North Shore so special. That's why we fight so hard. Because this nothing that you see is why people love this place. I say that because these developers come through, they see a mountain, they want to put a tourist attraction on it, they want to improve it in their image. And they're not improving it. It's already the way it's meant to be. So with your support, hopefully we can just nip this in the bud and stop coming up with these dumb ideas to over-exploit our Mauka lands. That's my testimony. Thank you for listening, and you guys take care.
Okay, thank you very much. Good to see you. He's our fellow, him, yeah, D and I. We entered the legislature at the same time. Good to see you again. Anyways, anybody else wishing to testify? Seeing none, nobody else on Zoom. Members, any questions? Representative Iwamoto?
Thank you, Chair. Mr. Rivera, thank you for your testimony. Included in this bill is a prohibition of funiculars. And I'm sorry if I'm not saying that correctly, funiculars. In other districts such as Wailaiki, there are private homes with funiculars already in existence. And I think there are some in Pacific Heights, but in different residential mountainous areas, there may be funiculars currently installed. As you read this bill, do you think those funiculars will have to be removed? Would this prohibit any future residential owner who lives on a very steep incline from having a funicular? That's my question. How do you read this bill regarding funiculars on private residential land?
I appreciate that question, and I think you're wise to ask for clarity on that. I'll leave that to the the legal folks in the legislature. I think the move would be to prohibit these items going forward. So if there was a grandfathered in item, that might work. It could be if for personal use only. I don't know. There's probably a way to keep this bill going and continue to flesh out that question.
So it sounds like maybe using the term commercial funicular might be a reasonable amendment.
Yes, how you word it, I think is to be determined, but
Okay.
I do think you're right to say if somebody's got a personal elevator, or some form, then maybe that should not be swept into this bill.
Okay, thank you.
Thank you very much. Good question.
Thank you.
Mahalo.
Any other members, any other questions? Seeing none, we are moving on. Next up, we have HB 2218 relating to DLNR. First up, we have OHA in support.
Hello, Chair, Vice Chair, members of the committee. OHA stands on its support. We have a long history of supporting existing community-based management structures, including helping to set up community-based sustainable fishing areas. So we are in strong support of this measure. Thank you.
Okay, thank you. DLNR, do you want to? We don't have you registered for some reason, but DLNR.
Yeah, good morning, Chair, Vice Chair, members. Alan Carpenter, Acting Administrator for the Division of State Parks. The department will stand on its testimony in strong support, and I'll just say that based on the overwhelming supportive testimony, I think this is a bill whose time has come. I think we have a little bit of tweaking to do, but yeah, this is gonna really enable a lot more community management across our system, not just for state parks, but for our entire department. So it broadens what we're currently doing to all our other divisions, and we'll be here for questions.
Okay, thank you very much. Next up, we have KUA in support.
Well, committee members, Kevin Chang, Executive Director of KUA. I know we stand on our testimony. I just wanted to make one point. I saw that there is one opposition. This colleague of ours, Phil Fernandez, I think he just doesn't know that within the bill, he says that this is a activity that will just give some rights over to activists. But we're talking about doers, people doing things who have long-term commitments to their place. And this bill actually allows the state to vet the communities that it should work with. So I just wanted to make that point.
Thank you very much. Next up, we have Nature Conservancy.
Nature Conservancy will stand on its testimony for strong support.
Okay, thank you. Next, we have Wana Ohana in support in person. Nope. Next, is there anybody else in person wishing to testify on this? See none. On Zoom, we have 60. Okay. Who's that? Kurt. Good job. Kurt. Wait, Kurt Cottrell is with DLNR. Oh wait, Kurt Cottrell? Individual, okay, as an individual. DLNR emeritus then. Kurt, are you on?
I am. Good morning, Chair Hassam, Vice Chair, and members of the committee. Yeah, this is my first legislative hearing as a civilian, so I'm appreciating the comfort of my home. But I just want to mahalo you guys for hearing the bill and for this opportunity to testify, with the caveat that you guys now know how to read. I will do on my written testimony in strong support with just the simple thing that's in my testimony, that piggybacking on the success of Ha'ena, there's a great opportunity to replicate this fairly quickly at Kealakekua Bay State Historic Park. So I'm anxious to see this piece of legislation move forward. And once again, thank you so much for hearing it. Mahalo.
Okay, thank you very much. Next we have Sierra Club in support.
Good morning, Chair, Vice Chair, members of the committee, Wayne, wow, totally connected. Wayne Tanaka, Circle of Hawaii. I will stand on our testimony in support of this measure. Thank you.
Wayne, we gotta shut off your Zoom link so you come in again.
Yeah, I'm actually jumping between multiple hearings this morning, so my apologies if I miss another bill. I'm jumping between this GP right now.
All right,
Thank you.
next we have Hui Maka Aina o Makana. On Zoom, are they on Zoom? In support.
Good morning, Chair, Vice Chair, members of the committee. This is Chipper Wickman. I'm the Vice President of the Hui Maka'ainano Makana. And I stand on my written testimony, and but just want to emphasize the incredible collaborative process that occurred over the last 6 months to prepare this bill and draft it, including strong support from Speaker Nakamura's office, but most importantly, the community that really pulled together. And I really thank Olan Fisher and Kua, Kevin Chang, for really using their networks to reach out to hundreds of individuals across the entire Pai'aina. This bill is, as you can see from the amount of positive testimony, is something, as Kurt said, whose time has come. And very appreciative. So thank you for hearing it, and thank you for your strong support. Aloha.
Okay, thank you. Next we have Billy Kinney in support.
Aloha, good morning, Chair, Vice Chair, committee members. I'm also with the Hui Maka'ainana o Makana. I'm the current Assistant Director. I just wanted to mahalo you folks for hearing this bill as well. The Hui is the org name in much of the support of this bill in the testimony. But I wanted to elevate also all of the other powerhouse Hui and organizations across Hawaii doing the same work. And one note I will make, one point I will make is that in our journey to get to co-management, we found that we get to a point where the pinnacle of co-management and legally, and the pathway stops at this point where the highest point is concession, where we're deemed vendors. That's at the very least, not what we do in terms of Malama Aina. So I think this bill is very important for the replicative care across Hawaii to help DLNR and the state and all you folks to do and us to do the best work that we do to steward all of our resources. So I think the Hui is very in huge support of this bill, and I hope that you will be too. Mahalo.
Thank you. Next we have Joel Edwards in support.
Aloha, good morning, Chair and members of the committee. I stand by my written support, and I just want to just add that as a community member and a small business owner here in Wainiha, something that wasn't in my testimony is how this initiative has not only strengthened the shared responsibility for Malama Aina, but has produced real on-the-ground results. Safer and more respectable access, stronger community trust, and most importantly, is good jobs for local residents. Community co-management creates employment rooted in place, allowing our local people to care for their home while supporting their families. And that economic stability strengthens stewardship and keeps knowledge and responsibility right here in our community. So for communities like mine, this is not theoretical. We're seeing it first place, what a difference it makes. And I appreciate you hearing the measure today. Thank you.
Okay, thank you very much. Next up, we have Hanalei Initiative.
Hi, my name is Joel Guy. I'm the Executive Director of the Hanalei Initiative. Thank you, Chair and members of the committee for hearing this bill. It's truly is an important part of our work out here in Haiena. We do stand on our testimony in strong support and yeah, available for any questions. Thank you.
Okay, that's all the registered testimony that we have. Is there anybody else wishing to testify? See none. Members, are there any questions? Representative Shimizu?
Thank you, Chair. Could I get DLNR, please? I'm in agreement with this bill, and I want to thank you for your testimony because you answered some of my questions. I just have one question. 65-year term, could that present problems as far as locking in arrangements that may not adapt well to future conditions, reduce flexibility for future DLNR leadership, or create legal complications if the organization dissolves or fails?
Good question, and I think we were actually discussing this just before the hearing, and I think one of the provisions we'd like to build in is a periodic review and report back to the board. And I think the current proposed term would be every 5 years. So it would, you could have a long-term agreement, but subject to review and approval by the board, kind of like a status report, so that there's a regular check-in, which I think is a good idea anyway.
Awesome, thank you. Great job, Chair.
Very good. Anybody else? Representative Poi Poi?
I guess for parks. What would happen in the event that there are multiple community organizations wanting to do similar work? How would that be vetted through?
Well, first of all, that'd be a nice problem to have, but these would be non-exclusive, right? In fact, that's one of the issues with the current AG opinion, that we cannot offer leases for this because leases have a degree of exclusivity built into them. So non-exclusive means you could have overlapping or similar activities going on at the same time in the same park, right? But I don't see it as a conflict. I see it as an opportunity to, if there's a group that's more interested in taking care of dunes and plants and another one that's more interested in
What if
taking.
they're both interested in doing the same thing?
I would not sure how precisely it would work, but I would say that they could probably both be offered a partnership to work together. I mean, but
In some
again, it's a
communities,
good problem to have.
they don't wanna work together, so I'm just trying to figure that part out.
Okay,
It's a hypothetical,
true.
but it's, you know, I was just curious about that part of it, because the bill doesn't speak to that specifically.
Okay.
And it's negotiated. It's not like the public auction part is removed, which is probably good.
Right.
But then how do you deal with the like conflicting proposals?
So
If there are.
you could potentially do what we do now, both formally and informally, is take a request for proposals and have it vetted in a competitive process and take the one that you think is best suited. Ultimately though, the board would have the say, right?
And then I did have a question, but it's more pertaining to the ocean, but because I think that this could also cover areas of ocean or nearshore water, so I'm wondering, like, it's not land, it's not easy to really delineate a boundary in the ocean, depending on where it is, so my question would be like, because this is so expansive across DLNR, that in all the different agencies, there are like so many different ways that this could apply. You know, how would it apply in a game management unit? How would it apply in the forest? Or and I know parks, we know that it works really well
Right.
so far. But I'm just wondering how it applies across like the broader scope of DLNR and specifically to nearshore waters, because I just think that that's a little bit of a harder area to form, like put management into like a boundary.
I agree, and we have folks from DAR and DOFA here. I think we're all excited collectively about the bill. But I think some of the other divisions, we've been the most proactive at parks, right? We've been kind of the tip of the spear on this one. I think we do need to get together, and we are getting together regularly to figure out how it will apply to the other divisions. But you're right about the water. But we do have, we have marine life conservation districts that are defined with boundaries and things like that. There are discrete units of ocean, I think, that have particular management in place. Or I could let Brian speak if.
Alright, I really like this concept and the goal, and I agree with it 100%. But then I just try and think through like the scenarios applied and like in practice, what does it actually look like? And so I have a lot of questions, which I can get together with you folks after too. But I'm in support of it. I just have a lot of questions of what it looks like applied across the department.
I appreciate that.
Yeah.
We internally need to be less siloed as well and work together. So I think we're all excited for the collaboration.
Thank you.
Thanks.
Representative Shimizu for the second time.
Thank you, Chair. DLNR, please. Sorry, DLNR. Rep. Poi Poi brought up a concern that I also had. So piggybacking off the 5-year interval. So after any 5-year interval, as you evaluate it and somehow it's not working, do you have the authority to cancel the arrangement and restart?
Absolutely. The board would have the power, right? So if there's an automatic review, I'm not sure if it would be an action item every time. But if someone's not performing, usually we would mutually agree, right, to terminate the agreement. Those are always built in.
Okay, thank you very much. Seeing no more questions, we're moving on. Next up, we have HB 1956 relating to fresh waterways. Give me a minute to catch up to myself. First up, we have the Attorney General. Comments?
Good morning, Chair and Vice Chair. Alyssa Kao, Deputy Attorney General on behalf of the department. The department offers several comments to improve clarity and reduce legal risk. So the first is the definition of residing is not very clear, and so to promote uniform application and to have adequate public notice of the conduct, we would recommend providing a definition for residing. We would also recommend providing a definition of fresh waterway, especially because most of our streams, freshwater streams do interact with some brackish water, so that might pose some issues with the definition there. And most importantly, our third and fourth comments talk about this timing of citations. That's also not very clear. So it would benefit from some clearer drafting as to when a citation and arrest could be issued. And finally, the bill's arrest authority, penalty structure, and procedural safeguards. Particularly, there's no written notice for personal protection of personal property. So those should be clarified, especially in light of the Davis v. Bisson case that came out this past year from the Supreme Court. And I think the bill would also benefit from some delineated agency roles since there is interaction with our law enforcement agencies, both at the state and county level and with DLNR. I stand available if you have any questions. Thank you.
Okay, thank you very much. And we have one individual in support, Jean Shimabuku. That's all the people that we have registered to testify. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Seeing none, we're moving on. Next up, we have HB 2151. Relating to building materials. First up, we have Crime Bureau, not here. Do we have anybody, that's all the people that we have registered to testify. Anybody on Zoom? Seeing nobody on Zoom? Anybody in the room? Seeing none. Members, questions to nobody? Seeing none, we're moving on. Next up, we have HB 1845 relating to the Land Use Commission. First up, we have the Attorney, the AG.
Good morning, Chair and Vice Chair and members of the committee. The bill, we would recommend a clarification, so to avoid any constitutional or statutory conflicts with the IAL or important ag lands provision, we would recommend amending the bill to clarify that lands that are IAL lands would still require 6 affirmative votes in line with section 201 or 205A, 2051 of HRS and the Hawaii Constitution. I'm available if you have any questions. Thank you.
Next, we have Office of Planning. Okay, we have, next we have Sierra Club in opposition. On opposite, is there anybody else present? Nope. That's all the people that we have registered to testify. We have a whole bunch of testimonies in opposition. Is there anybody else in the room wishing to testify? Seeing none, members, are there any questions? No, we'll go with Representative Belatti since it's her first question.
For the Attorney General, please. I tend to agree with your amendment that we should maintain the protection for the IALs. Can you explain more why that would be something that needs to be constitutionally protected?
So I think that the current bill would only require a simple majority of the affirmative votes, and the bill alters Article 11, Section 3 of the state constitution, which provides that IAL shall not be reclassified unless there's those 2/3 votes. So I don't think that the state statute could override that constitutional provision.
Thank you. I think, and again, that's because of the IALs being of something of great importance to the state.
Correct.
Okay, thank you. Thank you, Chair.
Thank you. Representative Shimizu.
Thank you, Chair. AG, since pretty much nobody else is here. Do you know if the commissioners are able to vote via proxy?
I'm not sure of that, but I know that Chair Ordecker is here, so he might be able to answer that question.
Thank you, Chair, members of the committee. Dan Hardanker. I'm the Executive Officer for the Land Use Commission. We did submit testimony. I'm not sure why it may have come in late. I'm not sure why you don't have it. But we would echo the AG's concerns. With regard to proxy, no, commissioners are not allowed to vote by proxy. I think in addition to the constitutionality, we have a couple of concerns. One is that it could result in only 3 commissioners approving a district boundary amendment, which is kind of a scary thing given the importance of district boundary amendments, number one. Number two, with regard to the Attorney General's testimony on important agricultural lands, one of the catch-22s that we have right now is that not all of the counties have designated important agricultural lands. So we don't know whether the lands that were being brought forward in a petition would qualify until that process is done. So just changing it to important agricultural lands is only going to work on Kauai, which is the only county to have designated important agricultural lands.
Follow-up question, Chair?
Yes, go ahead.
So you answered no to the proxies, but in light of the purpose of this bill, could you see language that might, be crafted to address this concern and still address maybe your concern?
You mean by allowing commissioners to vote by proxy?
Yes.
I would defer to the AG on that. I'm not sure we have anything in place that would allow that to occur. It might take a larger amendment.
Thank you, Chair Shimizu, for your question. I think that pursuant to the Sunshine Law, which is in Chapter 92 of HRS, proxies aren't generally allowed for boards and commissions, and the LUC would fit under that provision. So I don't think a special provision could be crafted for that, but I'm not certain at this time.
Thank you. Thank you, Chair.
Members, any
Second question.
Representative Baladi? We do have a, go ahead.
For the chair of the Land Use Commission, can you in very briefly summarize what was the testimony that you would have submitted? And then would you be open to an amendment that says that maybe that this kind of simple majority would apply only to those lands and not any county where IAL has not been designated?
Summarizing my testimony, I think I did that
Okay.
previously. Thank you, Representative. As far as amendments, I understand, if I understand properly. Yeah, I mean, if we're gonna do that, I still have concerns that, like I say, only 3 members out of a 9-member commission could pass it.
Thank you, Chair. Thank you, sir.
Okay, can you stay up there?
Sure.
So you said only Kauai put in IAL?
Kauai has completed its IAL process.
So from my understanding, IAL is a voluntary program, right, for private landowners?
Actually,
Is it a
Chair,
requirement? Because that would be a taking if it was forced upon the landowner. Is that correct or no?
this is the subject of a Supreme Court lawsuit right now. What happened was that Kauai started into its process, and it takes years to get through that process because it requires a lot of public outreach and notice to all of the landowners involved. By the time Kauai was done with its process, they were aiming at a certain percentage of their agricultural land to be designated IAL. By the time Kauai County was done with their process, the landowners on Kauai had voluntarily put that amount of land into IAL. So they said, okay, well, we don't need to complete this process because we've met our goal. The city and county of Honolulu then started up its process. And when it came to the Land Use Commission after they had completed going, it took them 7 years to go through the council and do all the rest. There was a concern raised by the landowners of exactly what you just said,
That's why we put the tax credit in place, right?
yeah,
Right? Because it's a voluntary process for private landowners.
well,
Did Mahipono put in their, didn't they designate their land as IAL?
some of it, and it was actually A
So
and B.
your testimony that's saying Kauai is the only place that has IAL
It
is
has- that
not correct.
there's-
Is that correct?
No, it is correct. Kauai
So
is the only
Maui
place
doesn't
that-
have IAL?
If I may, Chair, there are some lands that have been voluntarily put into IAL by landowners. But there is a process under the IAL statute that requires each county to designate lands within the county that are supposed to be designated IAL. That is not a voluntary process. The counties are given power to do that. The lawsuit that I was referring to put that process in question because some of the landowners came in and said, you're changing our ability to use our land in certain ways. And it had revolved around the ability to build farm housing and for the ability of non-agricultural workers to live on the land. And so the Land Use Commission balked and sent it back to the counties. The counties then appealed to the Supreme Court for clarification of that issue.
Okay, thank you very much.
Follow-up.
Yes.
What is the status of that Supreme Court case now?
They've had oral arguments, but that was like a year.
When was oral arguments?
Like a year or two ago, I'm not sure exactly. But we have not gotten a decision.
And what is the name of the case?
I think it's City and County of Honolulu versus Land Use Commission, I'm not sure.
Thank you.
I could be wrong about that.
Okay, thank you very much. We need to move on. We have an 11:15 deadline. Next up, we have HB 1844 relating to the Land Use Commission. Oh, you might as well stay up there. First up, we have Attorney General with comments.
Good morning, Chair and Vice Chair, members of the committee. The department offers comments on the bill. We offer two major comments. First is that the bill doesn't allow for public notice or participation requirements, so we would recommend adding in a requirement for notice and a public hearing. And second is the same issue that I had mentioned in the previous bill, is that both Article 11, Section 3 of the Hawaii Constitution and Chapter 205 of the Hawaii Revised Statutes impose specific standards and voting requirements for reclassifying IAL. So to avoid those conflicts, we would recommend for this bill that you would clarify that IALs are excluded from this process. Thank you, and I'm available for questions.
Okay, thank you very much. Next up, we have Farm Bureau's not here. Anybody else present wishing to testify? Seeing none. We have Sierra Club on Zoom.
Good morning, Chair, Vice Chair, members of the committee, Wayne Tanaka, Sierra Club of Hawaii. We respectfully oppose this measure. There are a number of other vehicles moving that will address, like go to the heart of the permitting delays and I think what this bill is trying to address. We just ask that maybe the committee and legislature explore those rather than pursue this path, which could lead to inadvertent significant impacts or cultural resources, public trust resources, food security, and so forth. Otherwise, happy to answer any questions. Thank you so much for your time.
Thank you very much. That's all the people that we have registered to testify. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Representative Iwamoto.
Thank you for the Attorney General's office. You mentioned public input. Wouldn't the public have an opportunity to provide input during the county's process of developing a general plan?
I can't speak to the protections that are available at the county. I would assume that if the county planning commission or whatever body is presenting it to, if there is a body that is attached to county government that is approving this to send to the land use commission, there probably should be some sort of sunshine meeting that could be able to provide notice. In this case, it may be more of an agency itself that's submitting the comments, so that period might not be available. I think the comments that we are recommending are more so in alignment with the public notice and hearing requirements that are reflected in like a district boundary amendment, because those are available. So we would replicate having those same sort of protections for this process as well.
Thank you.
Members, any other questions? Representative Shimizu.
Thank you, Chair. Am I able to ask the LUC Chair a question?
Just a point of clarification, I'm the executive officer, not the chair, so.
Sorry for that. I'm sorry, I'm not that familiar with this process and situation, so indulge me, please. Are there examples or reasons why the LUC would deny the county just agreeing with them and going along as this bill is proposing?
If I understand this bill correctly, it's a shall. The bill says shall, so we don't have any discretion. The concern, and this is staff's testimony, not the commission's. The concern that we have is that this bill may violate due process. It goes beyond simply what's contained in the Constitution. The Supreme Court decided the Town case back in the 90s, which requires contested case hearings for all district boundary amendments, because the US Constitution states that you can't deprive someone of property rights without due process. In the Town case in the 90s, the Supreme Court concluded that Chapter 91, which provides for 91 or 92, 91, which provides for contested case hearings, is the best way to ensure due process for each landowner and neighboring landowners on a district boundary amendment proceeding. So simply requiring the Land Use Commission to do a district boundary amendment based on a general plan doesn't meet those due process requirements. there's some concern that there is an issue there.
Can I ask a quick question? Can you summarize, we are on a time constraint here, so can you summarize the difference between what's your process that you usually go through and what this bill is proposing? So that way members can have a better idea.
Okay, the contested case hearing process is similar to a court hearing. People come in, they present evidence, the Office of Planning and the counties present evidence, and there's an opportunity for intervention. Say you're a neighbor who doesn't want to see this change, or you're the Sierra Club who has concerns about what's on the property, or even about cultural resources. They have the opportunity to intervene, present evidence, and explain to the commission why the district boundary amendment shouldn't proceed. The Land Use Commission then, as a judge would, weighs the evidence and then makes a decision. There's also a couple of other constitutional issues. Kapakai analysis needs to be done, which revolves around cultural resources and public trust doctrine. The general plans are just that, they're planning documents. They go out, my understanding is, and I'm not representing the county on this, is that the county goes out and it says, okay, we're gonna amend the general plan. And they hold hearings, meetings around the state. People come who are interested. There's no opportunity for cross-examination or for defense of positions or anything like that, or introduction of evidence. It's like a neighborhood board proceeding for the most part. And so there's no opportunity for due process to be met in those proceedings.
Okay, thank you. Go ahead.
So I just wanted to clarify, you made a statement about it's kind of like a taking without due process. When I read this bill, I thought it would allow greater opportunities for the landowners who are now considered part of the urban, because I don't know why I always think of if it's part of an urban zone, now suddenly the value goes up, because now instead of just, raising chickens, now you can build housing. That's what I thought.
Well, that is correct, Representative Miyamoto. There's an increase in value, but there's also an increase in tax liability. And that, we've actually had this happen with us a few times, where we've had concerns raised by landowners who maybe have had land in their families for generations, never built anything on it, don't want to build anything on it, there's a house on it, they might vacation on it once a year, and if it was moved into urban, they couldn't afford the property taxes. They can pay the agricultural taxes, but they might not be able to afford the urban taxes. There's concerns there about the change in the valuation, which is what due process is all about. If you're gonna change it so I have to pay more money, I need to have the ability to contest that.
But I think the argument would be that if you do develop it, because I think some of the concerns are for some communities is that there isn't enough housing, affordable housing, for instance. So these urban areas are trapped by non-urban areas in a way, and so there's nowhere for them to build out. And so if those lands, if everyone's like, no, I refuse to build, could the county, well, that's another question, could the county take the land through eminent domain, just saying this is a general plan we have?
Eminent domain is a complicated process, and there are constitutional issues associated with eminent domain. There has to be some nexus between a legitimate government interest and the reasons for property.
Thank you.
I'm not sure just growth is, I would defer to the.
And next, moving on.
Sorry, thank you.
Representative.
Attorney General,
Mandela.
please.
Go ahead.
Your testimony is absent of reference to town and Kapa'akai. Is there a reason why you folks did not look at those issues?
I think that our general concerns about due process and notice, though it didn't cite the litany of case law, that because town is the case from in the 90s. I think the last public notice, an opportunity to be heard case probably was in the late 2020 or the late 2010s or the early 2020s. So we didn't provide that litany of case law, but I think that our testimony about those two elements are being necessary or there. And I think we would defer to the LUC on any Kapa'akai analysis because we didn't see those concerns present in this bill because this bill mainly concerns the efforts of or the LUC's ability to grant the county powers without without affording landowners that opportunity to be heard and to provide notice to those owners.
Okay, so then a general amendment based upon that comment would be, which is you're actually asking for two amendments, both the IAL amendment, but then also a very clear specification requiring a public hearing process and notice.
Correct.
Okay, thank you. Thank you, Chair.
Thank you. Okay, seeing no more questions, we're moving on. Next up, we have HB 2103 relating to Land Use Commission. Let me see. What's up this one? First up, we have PLNR. Support.
Good morning, Chair, Vice Chair, members of the committee. Katie Roth with the Commission on Water Resource Management. We stand on our testimony in support.
Okay, next we have OHA in support.
Yes. I would invite questions. This is an OHA package bill, so if there's anything to clarify, I'd be happy to do so. And we believe these are modest amendments that we're requesting, but would address some of the water issues that have come up in a number of other bills this year.
Okay, thank you. Next up, we have Olan Fisher. Kua'aina. Au'umauno.
Kua.
Oh, Kua, okay. Sorry.
Olande Momi Fisher with Kua'aina Uluawamor. Kua is easier to say. And we stand on our testimony in strong support of this measure. Thank you.
I apologize for butchering your. I apologize in advance to everybody when I butcher your name. It's not intentional. Okay, next up we have, we'll do Sierra Club on Zoom.
The Sierra Club of Hawaii will stand on our testimony in strong support of this measure. Thank you very much.
Is there anybody else in the audience wishing to testify on this? See none? There's nobody else on Zoom? Members, are there any questions? Representative Shimizu?
Thank you. Can I ask LUC a question? How does the current LUC setup consider water and OHA concerns?
There are two ways in which we consider water and OHA concerns. Mainly through the Office of Planning and Sustainable Development, who is tasked with talking with all the other agencies with regard to their concerns. And that information is taken into consideration in the decision-making process. The water issues are extremely complicated. Sustainable yields, and things like that are often highly contested, and we don't have the expertise as staff. So we rely on the commissioners to understand what is being testified to. And often the hydrology and all the rest is very complicated. So we did submit testimony, but once again, I don't know, got lost in the ether. We just welcome any expertise on anything on the Land Use Commission because we get such complicated things coming in front of us.
I'm sorry, follow-up question?
Go ahead.
So do you see a benefit for this proposal to add two slots that are expertise in their respective areas?
Yes, I do. One of the things that, I can give you examples of other areas of expertise that we've had on the commission coincidentally. Engineers are very valuable because they understand the principles involved with infrastructure. Attorneys are valuable because they understand the contested case hearing process. We have had water experts on the commission, and they've been very valuable because they understand the complexities of hydrology and all of the rest. Any expertise that is associated with land use is welcomed on the commission.
Thank you, Chair. Thank you.
Is there any other question? I have a question for WAL. So the way I read this is there's two things. You want a water member and you want to appoint through your OHA process, the Hawaiian, how do I say this? The traditional Hawaiian land usage and knowledge of the cultural land practices.
Correct. So the water expert seat, there's currently no designation for any member to have that expertise, so that would be one. And then the second, there's already the traditional land use management expert, but we're asking that we provide the nominees to the governor, much like we do for the island burial councils.
Okay, thank you. That's a simple question. No other questions? Seeing none, we're moving on. Next up, we have HB 2424 relating to land use. And I need to catch up with it. First up, we have Office of Planning. Comments?
Chair, Vice Chair, members of the PSD will stand.
Okay, next we have Department of Ag in person. Comments?
Aloha Chair, members of the committee, Cedric Gates here on behalf of DAB. DAB stands on its written testimony offering comments and amendments to this measure. We're here for any questions. Mahalo.
Thank you. Attorney General?
Good morning, Chair, Vice Chair, members of the committee. The department offers three major comments for clarification and reducing risk. First is the comment that I've mentioned in my two previous measures about the IAL. So to avoid any statutory or constitutional conflicts, we would also recommend an amendment that would exclude lands that are designated as IAL from this process. We also have a concern about the due process requirement in this bill. So the bill currently requires counties to provide required due process, but it's unclear what additional procedures are intended beyond notice and the public comment already specified. So we would like some greater specificity so that there is consistent implementation. And finally, the bill talks about OPSD's role to appear at both the county and the state levels. While OPSD's role is very clear at the state level, it's not very clear what it would do at the county. So we would recommend some clarity on OPSD's role. I'm available if you have any questions. Thank you.
Okay, that's all the people that we have registered to testify. Is there anybody else in the room wishing to testify? Nobody else on Zoom? Members, are there any questions? Seeing none?
Oh,
we're
wait,
moving-
I'm sorry, is Sierra Club
Not on Zoom.
not here?
Okay.
I have a question.
Sure.
Maybe for the AG. Can you expound on what the rural designation is?
What the
rural district designation is and what kind of protections it might have that jeopardize IALs or lack of protections it may have? Because this bill is calling for designation to rural, right?
Yeah, so it would, it allows the county to reclassify those lands within ag to rural. And so because some of those ag lands may be, sorry, Chair, I'm sorry, Member Bellotti, I wanna make sure I answer your question. So the question is whether, is why this IAL language is needed. So the reason why is because it's not clear that these ag lands that would be transferred to rural are, whether they're IAL lands or just regular ag lands. So we wanna make sure that to protect those ag lands, we would say that it's protected from that process, and that it meets the requirements in both constitution and statute, with that 2/3 vote.
Okay, I guess moving forward, the rural designation, and it's not explained in any of the testimony, would allow far greater development that might threaten agricultural lands, and that's the concern.
That's correct.
Okay, thank you, Chair.
Okay, thank you very much. Members, any other questions? Seeing none, we are moving on. Next up, we have HB 1650 relating to environmental assessments. First up, we have Office of Planning with comments or support statement.
Good morning, Chair, members. Tom Eisen with the Environmental Review Program of the Office of Planning, Sustainable Development. Submitted testimony.
Thank you. Next up, we have, I think that's about it. Anybody on Zoom? Nobody else. We have nobody else on Zoom. Anybody else in the room wishing to testify? See none. Members, are there any questions? Oh, I have a question. Office of Planning. So reading the testimony, one concern came up, this is the Waikiki one, right?
Yes.
Yeah. So one concern came up that if it's along the shoreline, that it doesn't, taking this out will be a concern. But from my understanding, anything that's along Waikiki shoreline is already triggered for a 343 review by an SMA, right? So if it's an SMA, it doesn't take out anything in Waikiki.
Yeah, the county has their own requirement for SMA permits to go through an environmental review process. SMA is not a 343 trigger, but city and county requires the applicant for major SMA permits to go through
A
the
343.
process, and we support them in that.
Thank you. Go ahead.
Thank you.
Representative Iwamoto.
Thank you, Chair. Most of the land that this bill covers, is it technically in a coastal flood area?
It's the Waikiki Special District, which more or less what we know of as
Between the
Waikiki.
Alawai and the ocean?
Yeah, it's it's heavily urbanized. And I think the notion was most land that goes through 343, most of the triggers are for land to still have some, I don't know, naturalness. But with the cultural resources and all there, there could be some issues
Okay.
there, but it's I guess city and county could require environmental review on their own.
Okay, thank you.
If they thought it was important.
Thank you, Chair. I have a question. My understanding is county already requires a EA but the state also requires another EA, so this bill is trying to remove some duplicity and streamline the process. So are there things in the state EA that is above and beyond the county's EA that is valuable?
They're the same process, it's not duplicative, it's one process, one EA to satisfy either their needs or 343 needs, so there's no two EA processes for the one project.
Follow-up question, Chair. So I also read that this bill is reinstating EA requirements for historic sites, so is it the current situation that historic sites don't have to do a EA?
No, the current situation is historic sites identified on the state list or the federal list they do trigger 343. The first iteration of this bill removed both the historic site and the Waikiki Special District. This House Draft 1 essentially reinstates the historic sites trigger, or doesn't remove it, doesn't propose removing it. So it's in there now, and House Draft 1 keeps it in there now.
Cause if it wasn't for this bill, it would be taken out, is that what you're saying?
No, if it wasn't for this bill, it would stay in. The first draft, the original 1650 proposed taking it out. House Draft 1 deletes that, taking it out, so it keeps it in as it is now.
Okay, alright, thank you for clarifying that.
Right.
Thank you, Chair.
Representative Belatti.
I'm sorry, sir, you're with what group?
The office formerly known as OAQC, the Environmental Review Program
Okay.
of OPSC.
Okay, sorry, I think you're the right person. I've always understood the EA-EIS process to be one where you have to clear the EA first in order to get the EIS. So by removing the special district of Waikiki from the EA process, does it then eliminate it from all of the EIS process?
So a project can go direct to EIS, it doesn't have to go through EA first, then EIS, but this bill would propose removing any requirement for any 343 treatment for project.
So even the EIS, it's actually eliminating the EIS for Waikiki Special District so that all the residents who've been upset about, and look, there's all kinds of people upset about the Alawai. Basically, they would not have had a voice if this bill is enacted.
Well, there's other triggers, use of state lands, state funds, county lands, county funds are still triggers. So a whole lot of public projects would still trigger 343.
But say something like in Waikiki that didn't have state lands but would have been triggered under this is now gonna be swept out.
Correct.
Okay, so
Unless for some reason the city and county chooses to create their own requirement to go through the process.
okay, all right, thank you.
I don't
We should
think,
take that
right,
back.
if there's
They've
an
done it in the past.
environmental trigger, it will still trigger, right? Just because it's in Waikiki, it doesn't trigger, I should say, clarify that, right?
Yeah, if the only trigger is because it's in the Waikiki
Waikiki.
special, just that will go away, but all the other triggers stand.
Right, so all the other environmental triggers that would, environmental reasons that would trigger a 343 still exist.
Yes, all the
It
other
doesn't mean that it's exempt from 343, it's just saying that Waikiki, just because it's in Waikiki, it's not a trigger anymore.
If any of the other triggers
Is that
apply,
correct?
they would
Yes,
continue to
okay,
apply.
I think you should clarify that.
Can I ask another clarifying question then? A
Sure.
private property like a hotel that wants to do something that could be swept out of it now. So like if they wanted to build a seawall, now there might be other triggers, but potentially the building of a seawall by a private entity could be
That's
now.
a trigger, that's an environmental.
The use of within the shoreline setback area is still
Is a
a
trigger.
trigger.
Okay, what about some kind of, if they're far enough away from the setback, but within,
Yeah, I'm not sure where the SMA boundary is, cause SMA is a trigger for the city and county. But in theory, there could be some islands that are outside of the shoreline setback area, outside of any other trigger.
yeah,
And then
okay.
they would not go through.
But the fact that the language is in the statute at some point means that some legislature thought that there were pressures in Waikiki that deserved the trigger to begin with.
Correct.
Okay, thank you, Chair.
Yeah, it's, if you read the testimony, it's in the testimony.
Yeah.
It says when it was put in. Thank you. Any other questions? Seeing none? Thank you very much. Next up, we're moving on. Next up is HB 376 relating to cesspools. First up, we have, is Department of Health here? University of Hawaii not here in support. City, Hawaii County, on Zoom. No. Okay. Realtors, I don't see the realtors here. Oh, there you are, hiding in the back. Okay. Okay. Realtors are comments. Reef, Hawaii Reef Ocean Coalition. Oh. Anybody else wishing to testify? Seeing none, members? Oh. Right.
Chair, Vice Chair, members of the committee, Nahalani Carson's here on behalf of the Hawaii State Association of Counties. Forgive me, I don't see the testimony online, so I'll check where it's at and make sure the committee has a copy of it, but we're in support of this measure. Oh, yes.
No, sorry, premature.
Okay. Members, is there anybody else wishing to testify? Nobody else on Zoom? Members, are there any questions?
Yes.
Now you can go.
Yes,
Jim.
Chair, thank you
Okay.
for the county person. So this bill previously had money allocated. So the counties, or your position is that the counties will support this bill without the funding.
Yeah, I think the way the bill addresses some of the nuances that, like addressing if people have financial hardships, they might need to delay, or there's certain like topography, if the soil's not right, then it makes it a little more appropriate to all the different people that will be this will be relevant to. So in that regard, yes, still supportive.
Thank you.
Okay, thank you. Members, any other questions? See none, we're moving on. Next up, we have HB 2599 relating to aquatic protections. First up, we have CLNR. Support?
Aloha Chair, Vice Chair, members of the committee, Brian Nielsen, Administrator of Division of Aquatic Resources. We stand on support of this bill.
Next we have is Mike Nakachi, present. Ohana, no. Nobody on Zoom? So that's all the people that we have registered to testify. Is there anybody else wishing to testify? Seeing none, we have maybe 10, 15. testimonies and support. Members, are there any questions to DLNR? Representative Shimizu?
DLNR. Thank you, Chair. This bill says you can extend or provide a 5-year extension granted for financial hardship. How would that be determined?
I'm guessing we would submit budget requests related to this bill if it were to pass in terms of appropriations for, you know, whatever type of capacity needs were needed to implement this. That's my guess.
I'm sorry, say again?
My guess, we didn't you know, submit this bill, but my guess would be submitting budget requests as part of the legislative budget process.
Well, we passed 376 already. Oh, I'm sorry, that's what
Oh,
I'm stuck
other
on
bill.
376. My excuse, sorry about that, Chair.
Request to go back denied. This is not like floor session, sorry. No, what do you wanna ask though? On a serious note.
No, actually, I wanted to ask, how many numbers are there for level 1 and 2? What are we considering?
Oh, I know who you ask, White Realtors. You have it in your testimony.
Okay, thank you.
Is this relating,
We're going back to
yeah,
cesspools.
you know what, it's in the testimony, you can,
Thank you,
I'll
Chair.
point it out later.
Very gracious of you, thank you, Chair.
Request denied, sorry. I got overruled by the vice chair.
Sorry about that, Chair.
No problem. Okay, seeing no more questions, we're moving on. Next up is HB 1861 relating to counties. First up, we have Department of City and County of Honolulu. Okay, are you here? No? EPP is not here. Is there anybody? Is there anybody here wishing to testify? Seeing none. Anybody on Zoom? Seeing none. Members, any questions to nobody? Seeing none. Jesus. Okay, they should be here to defend their bill.
Don't pass it.
Okay, we will recess.
What?
Okay, thank you very much. We're reconvening our Committee on Water and Land. First up, we have HB 1881 relating to land use. The chair's recommendation is to pass this out with an HD1. Well, before I start, if I forget, all the bills will be deferred to 713,000. They'll all have technical amendments. So in the event that I forget to mention that. Anyways, going back to HB 1881 relating to land use, chair's recommendation is to add or to ban commercial funiculars rather than just funiculars. We'll take Representative Iwamoto's comments and we'll add that to the bill. Any comments or concerns? Seeing none, Vice Chair for the vote.
Okay, we're voting on HB 1881, recommendation to pass with amendments. Chair and Vice Chair vote aye. Rep. Palati?
Aye.
Rep. Ichiyama?
Aye.
Rep. Iwamoto?
Aye.
Rep. Hoi Poi?
Aye.
Rep. Woodson?
Aye.
Rep. Mizu?
Aye.
Rep. Souza? Aye. Your measures adopted.
Okay, thank you very much, members. Next up, we have HB 2218 relating to the LNR. The chair's recommendation is to pass this out with an HD1. We're gonna add a 5-year review. We're gonna take outer circles amendments and make a 5-year review under BLNR. And in the committee report, we'll put in for the next committee to see what happens, to look into the issue of two competing organizations wish to do the same thing, right? Is that correct? Do I get you a yes vote now?
Yes,
Okay.
you always had a yes vote,
Oh, thank you.
extra yes.
So, well, bold your check mark.
Okay.
I think, yes, that's it. Effect date 7/1/2000. Any concerns or comments? Seeing none, Vice Chair for the vote.
Voting on HB 2218, recommendation to pass with amendments, noting all members present. Are there any reservations? Any noes? Recommendation adopted.
Okay, next up is HB 1956 relating to freshwater waterways. The chair's recommendation is to defer this for now. I will work with the introducer to look over the AG's comments, and we may bring this back, maybe next week Tuesday, or after. So this is deferred. Next up, HB 2151 relating to building materials. The chair's recommendation is to pass this up with an HD1. HMSO pointed out that we don't need section 107, so I'm gonna delete that. I guess that's a tech amendment. And effect date to 7/1/2000. Any comments or concerns?
Yes, Chair.
Yes.
Thank you. I really, I had questions, but there were no testifiers for me to question. I'm concerned, one of the concerns I have is that I can imagine counties regulating just concrete in general, and to exempt hempcrete, I support hempcrete, but I think that to just deny any kind of regulations around something that has hemp in it, where other materials might be regulated is a little bit strange, so I'm gonna be voting with reservations.
I understand. Yes. Good. Any other questions, concerns? Seeing none, Vice Chair for the vote.
Okay, we're voting on HB 2151, recommendation to pass with amendments, noting all members present, reservations by Rep. Iwamoto, any other reservations, any other noes? Seeing none, your recommendation adopted.
Okay, next up, we have HB 1845 relating to land use. The chair's recommendation is to pass this out with an HD1. We're going to clarify that the LUC will still need 5 members to get quorum. And we will exempt out, or we'll we'll take the AG's amendments stating AIL will not be a part of this process, cause you still need a 2/3 vote. And adding language to section 2051A that the LUC still needs 5 members to get quorum. I just said that. And defect date to 7/1/3000. Sorry, I said that last section twice. So, any questions or concerns? Yeah, Representative Shimizu?
Chair, I support this bill, but there's so many negative testimonies. I'm gonna be voting with reservations and take it up in JHA where we can vet it more thoroughly. Thank you.
Thank you very much.
Same comment.
Okay, thank you.
Similar comment, but just that I appreciate the amendments and looking forward to seeing the J on a new draft.
Thank you. Is there any questions?
Same comment.
Good.
You're not in jail.
Oh yeah, accept that.
Vice Chair for the vote.
Okay, we're voting on HB 1845, recommendation to pass with amendments. All members present, noting reservations by Rep. Belatti, Iwamoto, Poi Poi, and Shimizu. Are there any other reservations or no? See none, your recommendation is adopted.
Okay, next up, we have HB 1844. Chair's recommendation is to pass this out with an HD1. I'm gonna take the chair's amendment and exclude out AIL. And this, instead of making an expedited process, I will make the process so the city will apply to the land use commission and they still have to go through the regular process, but they could be the applicant to change the land use commission boundaries based upon their general plan. But they don't get an expedited process. Oh, and the LUC shall use the data from the public hearing in the city. So in other words, if the city does an EIS or other studies, they can use that in the LUC's process. They don't have to redo it again. Any comments or concerns? Seeing none?
No, sorry.
I missed it.
Sorry, Chair. I'm just clarifying that this is not, you're not requiring the land use commission to automatically, you're not mandating them to reclassify.
Correct. They still have to go through their regular process.
Okay, thank you. With that, I'll be voting with reservations instead of no.
Okay.
Thank you, Chair, for your thoughtfulness. You moved me from with reservations to a yes.
Okay, thank you.
Thank you.
Stella, are you a yes?
I am a yes.
Oh,
Thank you for your amendments.
Okay, good. Vice Chair for the vote?
Voting on HB 1844, recommendation to pass with amendments. All members present, reservations by Rep. Iwamoto. Any other reservations?
Reservation.
By Poi, any no's? Okay, your recommendation adopted.
Okay, thank you. Members, next up, we have HB 2103 relating to land use. Chair's recommendation is to pass this out with an HD1. I'm gonna defect date to 7/1/3000. I wanted to make changes, but I don't think I have enough time now, so I think judiciary, it's gonna go to judiciary so they can review the bill even more. But I want the conversation to continue. So that's it. Members, any comments or concerns? Seeing none, Vice Chair for the vote.
Voting on HB 2103 to pass with amendments. All members present, any reservations?
Reservations.
Shimizu, any no's? Recommendation adopted.
Okay, next up, we have HB 2424 relating to land use. Chair's recommendation is to defer this for now. I'll work with the introducer to figure out the issues on that bill. Next up, we have 1650 relating to environmental assessments. Chair's recommendation is to pass this out as is. It's already defect dated to 7/1/3000. Any comments or concerns? Representative Iwamoto.
Thank you, Chair, for the opportunity to express my concerns with this bill. This is, as I expressed earlier during questioning, this is a coastal flooding area that will be, and I think any development needs to be suspect or a lot of attention needs to be put on to any kind of development that's gonna be happening in this area. So I'm going to be voting no.
Representative Shimizu.
Chair, I like the positives of this bill. It is a serious concern, but I believe it should move forward, so I'll be voting yes with reservations.
Thank you. Representative Belatti.
I'm going to vote with reservations. It really concerns me that typically with these types of bills, we should have a JHA referral and there is none. And so that's what concerns me, and we'll see what Finn can do.
Okay.
I'll vote with reservations as well.
Thank you. Okay, good. Members, any other questions? Seeing none?
Okay, we're
Vice
voting
Chair
on
for the vote.
HB 1650, recommendation to pass with amendments, noting reservations by Rep. Belatti, Shimizu and Souza, and no by Iwamoto. Are there,
As is.
I'm sorry,
As is.
HB 1650 to pass unamended as is. Reservations by Belatti, Shimizu, Souza. Any other reservations? Poi poi, any no's?
No.
Yes, I'm sorry, got
Sorry.
that. Recommendation adopted.
Okay, thank you very much. Next up, we have HB 376 HD1. Chair's recommendation is to pass this out with an HD2. Effect date to 7/1/2000 and add for the Department of Health to prepare and submit to the legislature an inventory of every remaining cesspool in the state as of January 1st, 2045, including the cesspools granted exemptions by the Director of Health pursuant to the subsection B, recommending whether or not and by what date the cesspool should be upgraded or upgraded or converted to a director approved wastewater treatment system, or 2, connected to a sewage system. Any comments or concerns? If you wanna see the detailed language, I have it here. Seeing none? Members, Vice Chair for the vote.
Voting on HB 376, recommendation to pass with amendments. All members present. Are there any reservations? Any no's? Recommendation adopted.
Okay, next up we have HB 2599 relating to aquatic protection. Chair's recommendation is to just pass this out with an HD1, effect date to 7/1/2000. And that's it. Comments, concerns? See none? Vice Chair for the vote.
Voting on HB 2599, recommendation to pass with amendments. All members present. Any reservations? Any no's? See none? Amendment, recommendation adopted.
Okay, next up we have HB 1861. The Chair's recommendation is to pass this out with an HD1, effect date to 7/1/3000. I recommend that we take the grassroots initiatives amendments. So that way the city has to, if there's excess funds, the city has to give it to the landowner. And I think this conversation should continue. This is the city one, right? Yeah, I know we all had a lot of questions, and nobody was here to answer them. But hopefully in JHA they will be there. And Della, you're in JHA?
As well as Rep. Shimizu and Rep. Poi Poi. We
So the
will
committee
watch.
has subpoena powers, you can subpoena them,
We
just
do
like
a lot of
Congress.
things, Chair.
So can we?
We did it well, you threatened to do it last year. Office of Planning showed up, right?
Are you daring me? Oh, not daring me?
Okay, yes, no, I'm just joking.
Uh-oh.
For the record, that's just a joke.
Yeah,
Okay.
joking.
Anyways, Vice Chair for the vote,
Questions, comments, concerns?
unless you're voting yes.
So if I'm voting no, then
We're gonna
comments.
skip over you.
Okay.
No, go ahead. Go
No,
ahead,
I'm
what do you
just,
want?
I know my concern is non-judicial foreclosures just as a concept, it's you know, it lacks due process. And
I understand. Yep.
Chair, yeah, I have serious concerns about this, I'll be voting no.
Okay. Any comments, any other comments or concerns? See none, Vice Chair for the vote.
Okay, voting on HB 1861, recommendation passed with amendments, noting the no vote by Rep. Shimizu. Are there any other no's?
No.
Okay, are there any reservations? Rep. Poi, any others?
I'll do reservations.
Lottie? Okay, recommendation is adopted.
Thank you very much, members. I believe that's the last. We are adjourned.
We have an